Look, you're not going to believe what I just witnessed. A federal courtroom. Complete chaos. I'm talking about the kind of scene you'd expect in a Hollywood movie, except this was real. This actually happened. The judge is still talking. Arguments are going back and forth. And then, out of nowhere, 3 senior attorneys just stand up. They gather their papers and they start walking toward the door. While the judge is mid-sentence, can you even imagine doing that? The level of disrespect, the sheer audacity. But here's where it gets insane. The judge doesn't hesitate, not even for a second. She looks at the marshals and says, "Block every exit, now." And suddenly, 6 US Marshals, fully armed, position themselves at every door. The attorneys freeze, literally freeze in the middle of the courtroom. People in the gallery are gasping. Court reporters' hands are shaking. Because everyone in that room knows this isn't some ordinary courtroom drama. This is something completely different, something massive. So what made these lawyers so desperate that they tried to literally flee a federal courtroom? What did they see that made them panic like that? I'm going to tell you exactly what the mainstream media isn't covering. The evidence that changes everything. That morning, just 48 hours earlier, the prosecution had submitted new documents. And these weren't just any documents. We're talking about encrypted messages, wire transfers totaling $4.7 million, and most importantly, a complete paper trail that led directly to the defendants. When the judge ruled that all 847 pages were admissible, that they could be used in court, the lead attorney's face went white. I mean, literally white. His co-counsel looked at each other in total panic, because they knew right then and there. Game over. But they tried anyway. They made one last desperate move. The lead attorney stands up and says, and this is recorded in the official court transcripts, "Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in this predetermined show trial." Strong words. Really strong words. But terrible timing. Because the judge was ready. She's been on that bench for 31 years. Appointed by Reagan himself. She's handled mob cases, terrorism cases, you name it. And she's seen every trick in the book. So she looks at them and says, "If you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." Silence. Dead silence. For 7 minutes and 23 seconds, nobody moved. Nobody spoke. The tension was absolutely suffocating. Now here's what really went down. On that same morning, the judge had received a sealed submission. Ex parte submission, which means only one side sees it. The defense team had no idea what was in it. And these kinds of submissions only happen when we're talking about something extremely serious. National security serious. Witness protection serious. According to sources inside the courthouse, that submission contained information about a cooperating witness, someone from the inside, someone who knows everything. And this witness was ready to testify. Think about the defense team's position for a second. They'd built their entire strategy on one assumption. Everyone's going to stay loyal. Nobody's going to flip. No inside information is going to leak. And then suddenly, they find out there's a cooperating witness. Someone who's going to testify against them. Someone who's been in protective custody since October. A former federal prosecutor told me, and I can't use his name because he spoke off the record. He said, when defense lawyers hear about sealed ex parte submissions, they know the walls are closing in. Someone talked. Someone sang. And now everything they've built is about to collapse. But it gets even worse. Later that afternoon, when proceedings resumed, the judge announced she was considering sequestering the jury. That means completely isolating them. No outside contact whatsoever. This only happens when there are serious safety concerns for witnesses, when there are threats, when there's an organized crime angle. And those documents, those 847 pages, let me tell you what was in them. Financial records showing that during the so-called blackout period, when there was supposedly no communication happening, there were actually multiple encrypted messages being exchanged. Direct communication, wire transfers from hidden accounts, all of it timestamped, all of it verified. A legal analyst on national television called it probably the most damaging paper trail he's ever seen in his career. "This isn't circumstantial evidence," he said. "This is a roadmap, point A to point B, money trail, communication trail, everything. The defense team knew that if this evidence got in, they had no defense left." Look at the timeline, because it gets even more interesting. This whole drama happened just 72 hours before the defendant was scheduled to testify. The defendant himself was supposed to take the stand, and inside the legal team, there was a major disagreement happening. The lead attorney was saying that testifying would be legal suicide. But the client was insisting that he needed to tell his side of the story. Now, with this cooperating witness in the picture, the entire strategy fell apart. Because if there's insider testimony, if the documents get verified, if the financial trail becomes clear, then the defendant's testimony could actually do more harm than good. Perjury charges could be added, obstruction charges could be added. Suddenly, testifying wasn't the problem. Not testifying was also dangerous. They were trapped. completely trapped with no way out. So when the attorneys finally returned to their seats, remember, the marshals forced them back. The judge made a statement that shocked the entire legal community. She said she was considering appointing shadow counsel. Shadow counsel means backup attorneys. They'd sit right there in the courtroom, ready to take over at a moment's notice if the current team tries to withdraw again. It's basically like having understudies in a Broadway show, except the stakes are someone's freedom, someone's entire life. I've been following legal cases for 15 years. I've never seen this happen. Never. And the financial consequences? Brutal. This law firm had already billed $12 million in legal fees. Now they're facing potential sanctions that could reach 7 figures. But money is actually the least of their problems. The real issue is disbarment. Career over, license revoked, out of the profession permanently. The New York State Bar Association immediately issued a statement making it crystal clear that attorneys cannot unilaterally withdraw once a trial has begun. 3 legal ethics professors gave interviews to major publications. Every single one of them said the same thing. This could be a career-ending move. But think about the bigger picture here. This isn't just about one trial. This is about precedent. If lawyers can just walk out whenever a case isn't going their way, what happens to the system? The judge addressed exactly this point. She said, "The court will not permit counsel to manipulate proceedings through calculated disruptions." Imagine if this actually worked. Every wealthy defendant facing conviction could just tell their lawyers to storm out, claim the trial is unfair, force a mistrial. The entire system would collapse. The judge understood this. That's why she took such strong action. The prosecution fought back too. Within 30 minutes, they filed an emergency motion seeking sanctions, $50,000 per day per attorney until proper courtroom decorum is restored, and they accused the defense of coordinating the walkout. They said it was pre-planned, timed to coincide with media coverage. Actually, this point is really interesting. News cameras were positioned outside the courthouse 45 minutes before the walkout even happened. Conservative commentators were already tweeting about judicial tyranny before the incident became public. Coincidence? Legal experts don't think so. The security situation escalated dramatically too. The US Marshals raised courthouse security to the highest level. They installed additional metal detectors, enhanced screening for all visitors. The NYPD deployed extra units around the perimeter. The FBI's New York field office put agents on standby. This is not standard procedure. Authorities were genuinely concerned about potential disruptions. Behind the scenes, even more was happening. During the lunch recess, there was an emergency meeting in the judge's chambers. Both legal teams were present. According to sources, the judge issued a direct ultimatum: conduct yourselves as officers of this court, or you will find yourselves as defendants in your own criminal proceedings. She revealed that contempt charges had already been drafted. They just needed her signature. The lead attorney, who's normally aggressive in court, reportedly sat there in complete silence for the first time in his career. So why does all of this actually matter? Because this isn't just another high-profile case. This is about the foundation that the entire legal system stands on. The justice system only works when everyone follows the same rules. Defendants, prosecutors, judges, attorneys, everyone. Let's look at the historical context. In American legal history, there have only been 3 comparable cases where defense attorneys attempted to abandon their clients mid-trial in federal court. In 1978, a mob lawyer tried it during a major trial. He faced disbarment threats. In 1992, during a banking scandal, forced to continue. In 2009, same result. And in all 3 cases, the defendants were ultimately convicted, and the attorneys faced severe professional consequences. The pattern is clear. The system allows vigorous defense. The system protects attorney-client privilege, but the system does not tolerate manipulation. When lawyers turn the courtroom into theater, when they try to convert proceedings into a political circus, the system pushes back hard. The jury's reaction is worth noting too. They weren't in the courtroom when the walkout attempt happened, but the afternoon tension was impossible to miss. One juror, a retired teacher, was repeatedly shaking her head during defense arguments. Another juror, a small business owner, was taking meticulous notes every time the judge addressed the defense team. Jury consultants say that when jurors witness this level of conflict between a judge and defense attorneys, they often interpret it as consciousness of guilt. The logic is simple. Why would lawyers risk their entire careers unless they knew their client was in serious trouble? Even on the international level, there were reactions. European legal observers were shocked. The UK's former director of public prosecutions commented that in any common law jurisdiction, this kind of behavior would result in immediate custody. French media ran headlines about it. Even Russian state media picked up the story, framing it as evidence of American institutional weakness. And that cooperating witness, the mysterious person who's been in protective custody since October, legal experts are speculating about who it might be. The leading theory points to someone in the inner financial circle, maybe a CFO, maybe a controller, someone with direct access to the allegedly fraudulent transactions. If this witness delivers the testimony that prosecutors are expecting, it could be absolutely game-changing. Complete timeline, financial records, internal communications, a paper trail that makes denial impossible, the defense's worst nightmare. Monday morning is going to be critical. The judge will rule on the mistrial motion, on the recusal motion, and she'll decide whether the witness testifies as scheduled. If the defense team attempts another disruption, the judge has made it clear there will be immediate arrests. US Marshals have already been briefed on arrest procedures for attorneys. This hasn't happened in living memory. The bottom line is this. This moment will define what the rule of law means in America. Are powerful people, wealthy defendants, high-profile attorneys above the rules? Or is the system strong enough to push back when boundaries get crossed? Whatever happens next in this case, whether it's a mistrial, a conviction, or years of appeals, one thing is absolutely clear. A precedent has been set. Federal judges in the future won't hesitate to take strong action when attorneys cross boundaries. That message is loud and clear. And maybe that's the most important lesson here. Justice doesn't just happen in courtrooms. Justice happens in the belief that the system is fair, that rules apply to everyone, that power and money don't put you above the law. When that belief gets weakened, democracy gets weakened. This courtroom drama tested that belief, and the system responded. Now we have to see if this response is just an exception or if it's the new normal. Time will tell.